Thank you. Hello, everyone. My name is Raj Day, and I lead the Cybersecurity and Data Privacy practice at Mayer Brown. Welcome to our discussion today, which we are conducting in connection with the firm's recent release of its guide, Preparing for and Responding to a Computer Security Incident, Making the First 72 Hours Count. Before we begin, I have a few housekeeping announcements. First, as we go along, we hope that you will ask questions by using the Q&A panel on the right side of your screen. We will make every effort to answer questions toward the end of the webinar. However, if we are not able to answer your question during the presentation, we will certainly try to follow up with you directly once the webinar has ended. Second, regarding CLE credits, while approval is pending, we will be providing an alphanumeric code at some point during the presentation. In order to receive CLE credits, participants must record this code on the virtual sign-in sheet that was emailed to you with the login instructions for today's program. With those program notes, allow me to introduce our participants today, including two of the authors of Mayer Brown's Data Breach Guide. All of today's participants are based in Mayer Brown's Washington, D.C. office. First, we have Marcus Christian. Marcus is a partner in Mayer Brown's Cybersecurity and Data Privacy Practice Group, as well as the firm's litigation and white-collar defense practices. Marcus spent much of his career as a federal prosecutor, and prior to joining Mayer Brown, served as the Executive Assistant U.S. Attorney for the Southern District of Florida, one of the largest U.S. Attorney's offices in the country. Second, we have Jeff Taft. Jeff is a partner in Mayer Brown's Cybersecurity and Data Privacy practice as well, in addition to our firm's Financial Services, Regulatory, and Enforcement practice. Jeff has extensive regulatory experience, especially with respect to privacy and data security issues at both the federal and state level. Third, we have Stephen Lilly. Stephen is a senior associate in Mayer Brown's Cybersecurity and Data Privacy practice. He is also a member of our firm's litigation and Supreme Court appellate practices. Prior to joining Mayer Brown, Stephen served as Chief Counsel to the Subcommittee on Crime and Terrorism of the Senate Judiciary Committee, where he focused on cybersecurity issues. We have a full presentation today, but before I turn it over to my colleagues, I wanted to set the stage for our discussion. Prior to returning to Mayer Brown earlier this year, I served as the General Counsel for the National Security Agency. In that capacity, I had a front row seat to witness the rapid evolution of the cyber threats that businesses face today. The challenges you confront are more complex than ever before in terms of the scope and scale of attacks, the actors involved, and the techniques used. We are seeing cyber adversaries continue to steal personal information and intellectual property, disrupt or even destroy business networks and data, and potentially manipulate products or systems as we all grow increasingly connected to the Internet of Things. At the same time, businesses also face potential risks associated with insider threats and third-party or supply chain vulnerabilities. Meanwhile, the regulatory and litigation landscape surrounding cybersecurity is becoming increasingly dynamic. I mention these factors not to unduly alarm you, but rather to impress our overarching point today, that preparing for and managing a data breach must be considered within this overall context, a rapidly evolving, complex threat landscape and legal landscape. In other words, data breach preparation and response is simply one element in a company's overall strategic approach to cybersecurity, which involves issues ranging from vendor contract management to regulatory compliance to litigation strategy. Handling a computer security incident can seem straightforward, but it can be far less so if one's company is not appropriately prepared, does not understand the regulatory context within which a response must be managed, or does not adequately anticipate the potential legal consequences that may arise, including litigation, following an incident. Today, my colleagues and I would like to walk through each of these areas in turn: preparing for a computer security incident, understanding the regulatory framework for responding to such an incident, and delivering an effective response in anticipation of litigation. So first, allow me to turn to Marcus Christian to talk about readiness and preparation.
Thank you, Raj. It is a pleasure to be here with everyone on the call. Thank you for joining us today. Now I'm going to be discussing readiness. Readiness really is all about how to reduce the likelihood of a breach and how to reduce the impact of a breach that occurs. Although I wish I could tell you that all breaches can be prevented, I really know the wisdom and the caution that there are only two types of companies: those that have been hacked, those that know that have been hacked, and those that don't. So the real question for companies is not whether they will be attacked one day. The question is whether they will be ready to respond effectively when they are. Responding effectively to information security incidents can be complex and involved. Building and maintaining an adequate response capability requires an organization to invest significant human and other resources into planning. One fundamental component of an effective response to an information security incident is a written plan. A written plan embodies an organization's formal, focused, and coordinated way to respond to incidents. A written plan promotes clarity and consistency, and it answers the essential but basic questions of who, what, where, when, how, and why. The goals and objectives for an incident response plan shape the structure of a company's incident response capacity and capability. Every company should tailor its information security incident response plan to its unique characteristics and requirements. Among other things, the plan should reflect the company's mission, its size, its structure, function, strengths, and its limitations. It should detail its resources and assets and have the committed and unequivocal support of management. Organizations' written plans generally include some common elements, however, even if they are tailored. Plans often include language expressing executive support, outlining major objectives, and describing their overall scope. Response plans also typically discuss the core stages of incident response, which include detection, containment, remediation, and recovery. In addition, incident response plans normally provide key definitions, and they provide categories to classify incident severity. Furthermore, many plans include a legal requirements section that lists the laws, regulators, and third-party contracts that impose notification and other requirements on a company. Finally, response plans should include the names of the people on the incident response team and their contact information. The people who make up the incident response team should come from multiple disciplines. Now, that might seem like common sense today, but response teams have not always been multidisciplinary. Until relatively recently, in fact, information technology departments generally bore the sole responsibility for maintaining information security and for responding to information security incidents. Over time, however, it became clear that this approach unreasonably required IT professionals to implement and maintain capabilities that simply were completely outside of their areas of expertise. That approach required IT professionals to carry out the necessary administrative, physical security, legal, and technical responsibilities of a robust and effective incident response program. But as you know, IT professionals generally do not track legal developments about information security safeguard requirements. 2, they normally do not have the authority to examine the personnel records of an employee suspected of stealing corporate trade secrets. And they generally lack experience in communicating strategically through multiple media channels to mitigate the reputational harm that can follow a data breach. As this slide you're looking at indicates, the people working on an incident response typically fall into 3 categories: internal team members, which are on the innermost circle; external team members, the next circle; and external organizations. The internal members of a response team are the company's employees. Internal team members often come from the following departments: information technology, information security, physical security, operations, legal counsel, compliance, human resources, communications, risk management, and from effective business units. Now, in a particular company, the names may be different, but the functions generally overlap. External team members come from firms maintained by a company to reinforce or complement the expertise and capacity of internal team members. External team members may have expertise in IT, communications, or the law. As also indicated in the slide, many outside parties can become involved in an incident response. Such outside parties include law enforcement agencies, insurance companies, and industry working groups. In addition, internet service providers can give useful information in investigating a breach. And software and hardware vendors can help incident responders fix the root cause of an intrusion. Truly, there are many organizations that can make incident response easier, but the aftermath of a breach is not the best time to look for them. Searching for necessary partners can cause needless delays. Whenever possible, companies should seek to determine the terms of engagement during the preparation phase, not during an incident response. Moreover, an organization's response plan should reflect a clear-eyed understanding of how and when to engage external support organizations, in particular law enforcement agencies. An effective response plan should ensure that the response team members have what they need to get the job done, even if networked computers, telephone systems, and other necessary tools have become compromised. Accordingly, a response team should have access to clean laptop computers, a secure means of communication, workspace, and other facilities and equipment. But some of you might be thinking that having the right people on a response team and having the necessary resources are not enough to ensure effectiveness. And that is because incident response teams need training and they need practice. Some training provided to team members should be individualized to correspond to their respective roles and responsibilities on the response team. In addition, team members should receive group training to help prepare for the emerging threats that they most likely will face. Response teams also should participate in tabletop exercises, which are simulated information security incidents. Tabletop exercises can range from short 30-minute exercises to very sophisticated and involved cross-sectional exercises that can occur across several hours. Tabletop exercises enable teams to improve their incident handling capabilities by working through realistic scenarios, by building rapport and coordination among teammates, by stress testing response plans, and by providing feedback to drive improvements. There are several areas where information security incident response plans may fall short of their intended purpose. First, a plan that lacks an executive sponsor is likely to falter because it does not have the necessary support to be successful. Second, even a well-written and battle-tested plan will become stale over time without regular updating to reflect business growth, personnel movements, regulatory changes, and emerging threats. Third, the failure to train response team members adequately will limit their ability to act effectively. And fourth, a response team must have an accountable coordinator who can ensure that the team members work together and execute the response plan with discipline. In today's regulatory environment, discipline is essential. More and more regulators are paying close attention to companies' language, implementation, and execution of their incident response plans. Last month, the FCC, and I mean the Federal Communications Commission, fined a major communications company nearly $600,000 in relation to a 2014 breach that exposed the personal information of not thousands or not millions of people, but of about 70 of the company's customers. After learning of the company's breach, the victim company notified the FBI, which investigated the breach and arrested the person who caused it. Now, despite that arrest, the FTC launched and conducted its own investigation. And during that investigation, the FCC scrutinized the company's response to its breach. In the end, the FCC concluded, among other things, that the company's response team failed to make the required notification to the FCC within 7 days after discovering the breach. According to the FCC, its 7-day notification requirement is to facilitate investigations by the FBI and the U.S. Secret Service. The matter was resolved when the FCC and the company entered a consent decree. The consent decree included a requirement that the company, and I quote, shall review, revise, and maintain its incident response plan to ensure that it is reasonable, comprehensive, and enables the company to detect, respond to, and provide timely notification in accordance with applicable law. The requirement included language mandating that the company shall perform annual test exercises of its response plan and subject this plan to third-party review. Raj?
Thank you, Marcus. I'd now like to turn to Jeff Taft to provide some thoughts on the legal and regulatory context within which you will be implementing the nuts and bolts planning that Marcus just described. As Marcus mentioned, regulators at both the federal and state level are more watchful than ever when it comes to computer security. So understanding this context is vital to developing and implementing any successful incident response. And with that, I'll turn it over to Jeff.
Thanks, Raj. Following up on Marcus's comments, I'm going to discuss some of the regulatory considerations in connection with an incident response plan. The regulatory considerations fall into two basic categories. The first is what is required by applicable law, regulations, and best practices or expected by the regulatory agencies responsible for protecting consumers or regulating entities. Second consideration is the potential risk for noncompliance with these regulatory requirements or the failure to satisfy industry standards or best practices. I'll start out by describing some of the various applicable frameworks, their requirements, enforcement actions related to their noncompliance with those laws and regulations. Because the U.S. relies on a sectoral approach to privacy and data security, the applicable laws and regulations will generally turn on the type of entity holding the data and or the type of data being held. Each of the laws, regulations, industry standards, or best practices that will be covered in the PowerPoint today are only covered at a high level. Given the limited amount of time, there's really no way to go into such great detail on each of them, but hopefully you'll come away with a basic understanding of what's required. The first law I want to discuss is the Federal Trade Commission Act, which is administered and enforced by the Federal Trade Commission. Under the Federal Trade Commission Act, the FTC has jurisdiction over most entities, with the notable exceptions being banks and insurance companies. In recent years, the FTC has become the lead federal agency on many privacy and data security matters. Section 5 of the Federal Trade Commission Act broadly prohibits unfair or deceptive acts or practices in or affecting commerce. While this law does not specifically mention privacy or data security, it has become a significant concern for companies as the FTC has used its authority under Section 5 to bring enforcement actions against numerous businesses for failure to maintain reasonable data security practices. One of the more recent and certainly higher profile actions by the FTC has involved Wyndham Worldwide Corporation. Even for those companies who are able to avoid an FTC enforcement action, an FTC investigation, including responses to a civil investigative demand, can impose significant costs on the company and tie up valuable internal resources for an extended period of time while the matter is being resolved. The FTC's use of Section 5 is not new. The FTC Section 5 authority for privacy-related matters dates back to 1998 and its enforcement action against GeoCities. As noted, the FTC's role in privacy and data security matters has dramatically increased over the last few years. In recent years, the FTC has focused on data and cybersecurity incidents and brought claims against at least 50 companies, whom the FTC believes maintained unreasonable data security practices or deceived customers about those practices, including practices related to companies' responses to computer security incidents. As previously noted, the Wyndham case has generated significant notoriety, and a couple of other cases are also noted within the slides for your benefit. Because the FTC Act does not specifically address data security and the FTC has not promulgated regulations setting forth any standards, the only meaningful source of guidance comes from those enforcement actions. In these actions, the FTC has clearly indicated that the development and implementation of an effective incident response plan is an important part of avoiding an unfairness claim in the data security context. I want to emphasize the point that having a policy, procedure, or program is not the same as implementing it. In my experience as a compliance lawyer, too many companies have outside firms prepare policies and plans and procedures that ultimately end up on the shelf in a 3-ring binder collecting dust. Effective implementation requires training, testing, and adjusting to reflect changes in circumstances and personnel within the company. Let me switch now to Gramm-Leach-Bliley, the Gramm-Leach-Bliley Act. Section 501 of the Gramm-Leach-Bliley Act requires financial institutions to safeguard consumers' financial information. Financial institutions for purposes of GLBA are broadly defined to cover any entity that's engaged in financial activities, as determined by reference to the Bank Holding Company Act. The safeguarding requirement is implemented through regulations issued by the federal banking agencies, the FTC, the SEC, and other prudential regulators. These regulations generally require financial institutions to develop and implement a customer information security program. Under the safeguarding rules, each bank is expected to identify reasonably foreseeable internal and external threats that could result in unauthorized disclosure, misuse, or destruction of consumer information or customer information systems, and take appropriate steps to manage and control those risks. Managing and controlling the risks could include a number of steps depending on the facts and circumstances. These steps could include monitoring systems and procedures, training staff, and overseeing third-party service providers. Even if you're not a financial institution who's covered by GLB or the safeguarding regulations, these rules can provide helpful guidance when developing your own policies for safeguarding your important information, including customer information. In the case of banks, the federal regulatory agencies have also used their authority under the safeguarding provisions to issue interagency guidance on response programs for unauthorized access to customer information notice. At a minimum, a bank's incident response program should contain procedures for addressing the following. 1, assessing the nature and scope of an incident and identifying what customers, information systems, and types of information have been accessed or misused. Notifying its primary federal regulator, or as soon as possible when the institution becomes aware of an incident involving unauthorized access or use of customer-sensitive information. Taking appropriate steps to contain and control the incident to prevent further unauthorized access to or use of customer information, for example, by monitoring, freezing, or closing accounts while preserving records and other evidence that may be needed for the investigation. And finally, notifying customers when warranted by the facts. Generally, customers' notification is required when the institution determines that there's been unauthorized access to sensitive information and misuse of this information has occurred or is reasonably possible. For the securities industry, FINRA issued a report on cybersecurity practices in February of 2015. This report also sets forth principles and effective practices for responding to information security incidents. The federal agencies responsible for implementing the safeguarding rules have also been granted enforcement authority. The SEC has exercised this enforcement authority against entities who have failed to satisfy these requirements. For example, in September 2015, the SEC brought an enforcement action against an investment advisor for failing to adopt written policies and procedures reasonably designed to protect private customer information stored on its third-party servers after hackers gained access. The enforcement action shows that the SEC will aggressively pursue GLBA Act and Reg SP violation regardless of the harm suffered by consumers, remedial actions taken by the parties, or the size of the firm. In addition to the enforcement action, the SEC's Office of Compliance, Inspection, and Examinations has an ongoing cybersecurity initiative that includes a second round of cybersecurity sweeps of registered IAs and broker-dealers. The examination focuses on written policies and procedures related to cybersecurity risk. FINRA has also done a survey and a sweep of broker-dealer cybersecurity policies and procedures last year. While GLBA generally covers financial institutions, it covers financial information, healthcare information at the federal level is protected by HIPAA and the implementing regulations promulgated by the Department of Health and Human Services. These regulations require protection of certain health information and notice when such information is compromised. In addition, these regulations required covered entities to have and implement policies and procedures to address security incidents, including those to identify and respond to suspected or known computer security incidents. HHS has enforcement authority and has taken a number of enforcement actions against a number of companies who have failed to protect information or respond appropriately to an incident. Before moving on to state law, I want to note that there are other federal agencies who have become increasingly active with regard to cybersecurity matters. For example, the Department of Defense recently released expanded interim rules that require notification in the event of a computer security incident on a contractor's network. Marcus already mentioned a recent enforcement action by the FCC, an agency that figures to play an increasingly large role in this area going forward. Other actors considering action on cybersecurity and data privacy include the National Highway Traffic Safety Administration and the public and private bodies that regulate electric power plants and power companies in the United States. In addition to these federal laws and regulations, there's a panoply of state laws and regulations related to privacy and data security. States have taken the opportunity to address gaps in the federal privacy and data security laws. State data breach notification laws are one such example. While 47 states in the District of Columbia have data breach notification laws, these laws are not uniform. This lack of uniformity can present a number of vexing issues when trying to decide whether notice is required under state law. In particular, the definition of key terms such as personal data and breach can vary from state to state. For example, some state laws include medical information in their definition of personal information, while others don't. These state laws typically require the owners of personal data to provide notice to consumers and possibly notify state regulators or the credit bureaus in the event of a breach or unauthorized access to consumer information. Notice is typically required as expeditiously as possible and without unreasonable delay. Sometimes notice under these state laws can be delayed if law enforcement believes that notice could compromise their investigation. The specific state notification period can be as short as 2 weeks, so it's important that you check the particular state laws. Some states don't provide a specific date or time period, so you have to be very careful with those state laws. To address the lack of uniformity in treating all customers in a similar manner, many clients adopt what is generally called the lowest common denominator approach. Under this approach, a company will typically follow the state law that has the most onerous requirements rather than trying to comply with the various requirements in each state. Practically, this means that if notification is required in 1 or 2 states, you would generally provide notice to consumers residing in all of the states, even if the applicable state data breach notification law is not triggered by the breach. While these notification obligations typically apply to the owner of the consumer's information, service providers often have an obligation under these state data breach laws to notify the owner of the data, and is that owner of the data who is then required under the state data breach laws to notify the underlying consumers. I wanted to highlight 2 points with respect to the form of the notice and the delivery of these consumer notices. With respect to the form of the notice provided to consumers, most of the states, with maybe the exception of Massachusetts, require a description of the incident, the type of information compromised, and the steps that the consumer can take to protect themselves. Oftentimes, this would involve giving the consumer information about the FTC's programs on identity theft and other things like that that they can use to protect themselves. The California data breach law was amended last month, and these changes are mentioned on the slide. The revised law provides specific guidance regarding the form of data breach notices, including the title and headings which are required within such notice. In particular, the law draws upon research that was done by the California AG's office, in which they determined that many of the notices that consumers were provided were hard to understand and consumers really couldn't differentiate what was the important information within these notices. The attempt to remedy this has been having these more specific headings and titles within the letter. While these laws are not yet effective in California, clients are starting to modify their notification letters to address these requirements, as most of them use a lowest common denominator approach, as we described before. While notice is typically provided to consumers through U.S. mail or other directed communications such as email, the state data breach laws also provide for alternative means of notice in certain circumstances. For example, if the number of consumers to be notified exceeds an established threshold in the statute, or you do not possess the contact information for the affected individuals, you may be able to post notice on the website or provide notification to statewide media. This alternative approach is often used in the event of credit card breaches where the retailer lacks contact information for the customers. Therefore, they will typically post something on their website, or they'll make a release to the media, and the media will report that there was a breach that occurred, and anybody who had used their card from a period of time at that merchant should be cautious and be on the lookout for suspicious activity with respect to their identity and their credit reports. Other states, such as Massachusetts, have issued regulations establishing minimum standards for safeguarding personal information. These regulations have some of the more detailed requirements, including vendor management standards and encryption requirements for information in transit and information that's retained on portable devices. While these standards typically apply to Massachusetts residents only, they have a broader reach because, as previously noted, many companies adopt the lowest common denominator approach when complying with state privacy and data security laws. Because it's impractical to only require encryption of Massachusetts residents' data on laptops and other portable devices, most companies just encrypt all of the information regardless of where the consumer lives. In addition to federal and state laws, there are industry standards such as PCI DSS and best practices such as the NIST framework for cybersecurity and ISO 27701. PCI DSS applies to companies handling credit card information and is enforced by the credit card associations under their rules and agreements with participants. There are substantial penalties for non-compliance with the requirements, and entities are generally required to hire a payment card industry forensic investigator to investigate and report on breaches involving credit card information. Earlier this year, the PCI Security Standards Council issued a how-to guide for incident management, which reiterates that the PCI DSS standards require entities to implement an incident response program. While not law or regulations, private lawsuits often allege that the failure to meet an industry standard such as PCI DSS or a best practice is negligence. Furthermore, with respect to PCI DSS, several states have included these standards in their statutes for purposes of assessing costs and liability arising from a data breach. With that, I want to turn it back over to Raj.
Thank you, Jeff. For our final presenter, I would like to turn it over to Stephen Lilly, who will describe the elements of an active response and the legal issues that can arise as you both respond to the incident itself and prepare for litigation that is likely in its wake. So, Stephen, over to you.
Thank you, Raj. As Marcus and Jeff discussed, developing and implementing an incident response plan within the context of the relevant regulatory expectations are crucial preparatory steps that a company should take in anticipation of a computer security incident. In this section, I will discuss key considerations for a company as it responds to an actual computer security incident, and I will do so with a particular eye to possible litigation consequences. We use the term active response as a shorthand for the process of responding to an actual computer security incident. This is not a term of art, however, and it merits emphasis that there is nothing extraordinary about the elements of the active response process. At bottom, cybersecurity is another enterprise risk that companies can address with the familiar tools of enterprise risk management. Companies likewise can respond to computer security incidents in the same way that they would respond to other incidents that substantially disrupt their businesses. In fact, many of the building blocks of an effective response to a computer security incident are the same as those for a company's effective response to a natural disaster, a criminal act, or other business disruptors. At bottom, just like other types of incidents, an active response to a computer security incident requires a company to learn what happened and devise and implement an effective plan to restore security and operations. The active response process generally can be described in terms of a handful of fairly distinct phases. Before touching on those phases, however, it is worth emphasizing 5 cross-cutting priority issues that are important throughout the active response process. As you will see, these cross-cutting priority issues highlight the similarities between response to a computer security incident and to other significant disruptive events that a company may experience. First, the investigatory function is central to the active response process. Determining which systems were compromised, when, for how long, by whom, for what purpose, and answering other such questions are crucial steps towards both remediating systems and limiting legal, reputational, and financial consequences. Unfortunately, certainty may be elusive. A retailer may find, for example, that it cannot determine exactly when malware began operating as designed on its systems, a key fact for legally required notification and any future class litigation. The company should be prepared for such uncertainty. Relatedly, the team must be sure to document the actions it takes and the facts it develops. This documentation serves a number of important purposes. For example, it helps to ensure accountability within the team. The active response period can be intense, and a written record of actions taken is the best method for ensuring that lessons learned can be captured accurately and that senior leadership can oversee the incident response function appropriately. The response team also should remain cognizant of the importance of maintaining privilege. This should be a topic of particular focus for representatives of a company's legal department and any outside counsel. Of course, the attorney-client privilege does not cover every element of an incident response in which an attorney participates. Nonetheless, the attorney-client privilege likely will protect communications with counsel to obtain legal advice. Work product protections also may apply to investigations performed by counsel in anticipation of litigation, as stated in advance in a letter to counsel. Generally speaking, these protections are more likely to apply to engagement with external counsel, since a court is more likely to view in-house counsel as engaged in business functions. Finally, as Jeff discussed, companies often face numerous notification requirements. Some are statutory obligations to notify consumers or regulators. Other requirements are contractual and demand notification of business partners or other third parties. Managing these notification requirements can be a fluid process during an active response, as the triggering dates for different groups of consumers, government entities, and business partners may depend on the particulars of a compromise, such as when a particular server at a particular venue is compromised and when remediation is complete. Preparation can be crucial. For example, a company that's inventoried its contractual notification obligations, many of which impose very short timelines, will stand a significant advantage. So too will a company that's thought through the fact that while its various disclosure obligations are legally separate, they are practically connected. Telling one state attorney general about a computer security incident, for example, will create practical pressure to tell others. A company's decision of how much to disclose and when also is complicated by the fact that the company likely will be operating with imperfect information. For example, it may not know the identity of every affected consumer, as Jeff highlighted, so it may have to consider using alternative notice that broadly publicizes the computer security incident. In sum, notification should be a consistent focus during the active response process. And this is particularly true in light of the near certainty that any class action litigation will allege inadequate and untimely notification. For example, claims alleging inadequate notification in violation of various state data breach notification statutes appeared both in the recent class action complaint against the Trump Hotel claim chain and in the 2009 complaints related to the Heartland breach. With those priority issues in mind, we come to the first phase of the active response process, detection. A company should have technical tools in place, tools that are reflected in a written information security plan, that help it to detect a computer security incident. Companies should recognize, however, that detection of a computer security incident often is the result of notification by a third party, such as law enforcement, a card brand, a cloud provider, or the press. A company's initial steps after learning of an incident are crucial to setting the tone and scope of the response. Thus, as described by the response plan, the identification and triage period will include the key steps of alerting the response team, determining incident type and scope, mobilizing resources, and preserving evidence. Assessing legal ramifications when possible is also important. A detailed legal review may be impossible. However, resolving even basic questions can substantially help companies manage the regulatory and legal implications of an incident. For example, a company may be able to determine whether personally identifiable information or personal health information has been compromised, or whether the data involved resides on company or third-party systems. Containment and eradication are the next two phases of the active response process. The containment phase can present difficult challenges that a response team must navigate with imperfect information. Premature action can have the effect of notifying a hacker that the compromise has been discovered, causing the hacker to remove evidence from the system or cause further damage. Conversely, delayed action can prolong an incident unnecessarily, expanding the number of compromised records or otherwise increasing the harm and litigation exposure. Here, practice and effective working relationships will prove very valuable. The eradication and remediation process likewise can raise challenges, particularly with respect to the extent of remediation that must be undertaken and the resulting expense and disruption of the company's business. Here again, the company will be well served by not considering these questions for the first time in the context of an active response. And in both phases, the use of a prudent and rational process to resolve these challenges will be important, both for reaching optimal outcomes and for minimizing litigation risk in the future. Recovery and capturing and implementing lessons learned represent the final stages of an active response. The active response process can be very challenging for a company. Ultimately, however, it should leave the company stronger. Specifically, the company should be better capable of addressing future cyber threats in two key respects. First, the recovery process should ensure that the technical threats and vulnerability knowledge gained during an incident response is fed into the company's cyber defense. In other words, that appropriate patches are put in place and that any signature-based systems are duly updated. Second, the incident response process should be strengthened through any lessons learned during the incident. The incident response plan and team should be assessed and updated as appropriate. For example, an incident response may demonstrate the need for further training of a department not previously anticipated to play a central role in incident response, or it may show that resources should be expanded or recalibrated in some way. Whatever the lesson, it is important to be discerned and implemented. As with the other phases, any perceived failure to take these steps of the active response process can have substantial litigation consequences. For example, the FTC's enforcement action against the Wyndham hotel chain alleged that the company failed to learn from prior breaches, resulting in significant harm to consumers. That brings us to the topic of the litigation fallout from a computer security incident. This is a subject that could take up an hour by itself, so we'll just touch on some highlights. As Jeff discussed, the FTC has been very active in this field. And of course, private litigation also has been an unfortunate repercussion of many computer security incidents. Consumer class actions continue to be the most common feature in the aftermath of data breaches. Shareholder derivative litigation and securities class actions also have been pursued, albeit with less frequency than consumer class actions. We are also beginning to see litigation, including with respect to the Internet of Things, relating to the future of cyber threats, most notably the possibility of manipulation of devices or systems. Almost uniformly, the plaintiffs in these actions know little or nothing about the actual facts of the company's data security practices or the decisions it made in the active response process, such as when to notify consumers. Whether a company is named in a class action or other complaint thus depends in large part on the public perception of the breach. Certainly, the larger the incident, the more scrutiny it will bring. But effective management of an incident, including by providing credit monitoring, clear notices, and otherwise avoiding substantial negative press, can reduce the resulting litigation risk. Strong defenses exist, but certain courts have allowed data breach class actions to survive standing challenges and motion to dismiss for failure to state a claim, ensuring some uncertainty for companies. For example, the Seventh Circuit's recent decision in Ramírez versus Neiman Marcus raised questions about the strength of standing defenses in the Seventh Circuit. Under the court's holding, the allegation of future harm from a prior data breach can be sufficient to establish standing since, in the court's view, the purpose of a hack is to allow identity theft or credit card fraud, both of which events can cause lost time and expense for consumers. Whether this approach takes hold in other circuits remains to be seen. At minimum, the Seventh Circuit's decision has created a more favorable forum for future litigation. more favorable for plaintiffs, I should say. That said, it merits emphasis that litigation arising from a computer security incident can be vigorously defended. For example, the allegation of specific harm sufficient to establish standing may well prove fatal to class certification. Consequently, while the law remains in flux, it is not the case that companies that suffered a criminal data breach must be victimized again by unfair and baseless litigation.
Thank you, Stephen, and thanks to all of our presenters today. I'd like now to turn to some of the questions that have arisen in the context of our presentation. So first, let me present to you, Marcus. Given your background in law enforcement, basically running a U.S. Attorney's office in a major district, when is it appropriate to engage law enforcement in the context of a data breach, and what are the pros and cons of doing so?
I'd like to point out a couple things. One is there are a few myths about involving law enforcement or some kind of reflexive approaches that some companies have taken. I've been on panels where people have said, you never contact law enforcement, and that certainly misses the point that sometimes law enforcement can provide benefits, which I'll talk about very shortly. But the reality is you cannot, oftentimes you can't avoid involving law enforcement. At least in 2013, I believe, federal law enforcement was involved in notifying companies of about 3,000 breaches. So they're very closely involved. But one of the things that people need to think about if they're going to approach law enforcement is the issues involved. You need to balance privilege and confidentiality and think about the benefits of engaging law enforcement. One of the things that you also need to do is the point about or the decision to engage law enforcement is not something you can make after the breach completely. There need to be established relationships that take place beforehand. With the FBI, there are certain threat sharing and informational groups, one called InfraGuard, that companies can sign up for. With the U.S. Secret Service, there are also electronic crimes task forces that you can become involved with and establish a rapport. And the rapport is important. Most people don't generally get involved with law enforcement, don't generally have interactions with them. And the popular perception or understanding is fear is that they'll have the police tape around your business and operations are shut down. So if I had to boil it down, come to your criteria, understand that there are benefits, but there could be costs. And I want to just relate one war story that another former government prosecutor mentioned in representing a client. Was one time law enforcement came in, and I don't think the law enforcement had a lot of experience, and was interacting with someone other than a lawyer in the company. And the member of law enforcement basically asked for all of the backup tapes from the company. Now, regardless of whether a company has anything to hide, that's certainly an overbroad request, and having an attorney involved will help to narrow the scope of that. And also having a rapport and comfort with law enforcement will give people greater comfort in pushing back.
That's very helpful. Thank you. Okay, second question, and Stephen, perhaps this is most appropriately directed at you. What are the types of claims that are generally made in the data breach class actions that we've seen to date? If you could boil them down to the generic types of claims that tend to recur most frequently.
Sure. So typical claims in data breach class actions involve alleged violations of data breach notification statutes, and that goes to often allege both inadequate notification and untimely notification. Also, you'll frequently see alleged violations of state consumer fraud actions, and this is particularly interesting in the context of the FTC versus Wyndham action, because a lot of the state consumer fraud statutes are interpreted to be consistent with the FTC Act, or Section 5 of the FTC Act. So as a result, you'll see actions or claims for deception and unfairness and unreasonable security practices under those state statutes. There are also a variety of common law claims that you'll see, most frequently negligence in the context of the security measures that were implemented prior to a breach. Also implied contracts. So, for example, in the retailer context, you might see a claim that when someone used a credit card to buy a T-shirt at a retailer, they also were paying for some basic level of data security. You'll also see claims for unjust enrichment, whether on the theory that someone didn't get the benefit of the bargain or that there was just something fundamentally unfair about not protecting data after receiving it during a transaction. Courts are still wrestling with the sufficiency of these types of claims when they're pled. And I should add also that these claims we've seen a lot of these claims in the data breach class action context. Obviously, there are different types of computer security incidents, whether the theft of trade secrets or the manipulation of data, and those future litigation on those topics may give rise to different types of claims.
Thank you. That's very helpful. Another question that has come up in different contexts, Jeff, maybe I'll direct this towards you. Although you discussed a number of the regulators involved in this space, and different regulators, of course, will apply to different companies who may be listening to this call, what are some overall trends you're seeing in the regulatory space that cross-cut specific industry sectors?
I think there are a couple, Raj, that are worth mentioning right now. The first is really third-party vendor management. That's an issue that the banking regulators have historically looked at and expected banks to have very robust procedures in place to manage it and oversee and audit their vendors. We're seeing it a lot more, though, in other regulated space, such as with the SEC and with FINRA, and even with the state insurance regulators. There's a general view that obviously your cybersecurity defenses are only as good as your weakest link, and I think the regulators view vendor as one of the weaker links that the institutions have. And you know, the news stories on Target and some of the other large-scale breaches tend to bear that out, that it's really been a third party that's provided access to your system. So I think that's an important point, and that people need to be aware of vendor management, and that means having contractual provisions that your vendor has adequate security, but also doing auditing and specific things like that to actually verify what your vendor's repping and warranting to you. The second thing I would talk about, and I highlighted a little bit of this in the presentation, is that implementation is very key with the regulators. Regulators want to see that you're actually training and testing on your policies and procedures. They recognize that it's very difficult to do a dry run the first time you have a security incident. So they want to see you not only doing test runs, tabletop exercises, but they also want to see you making changes to your policy based upon what you learned from those exercises, so that it becomes this kind of a living, breathing document rather than just something that's on a 3-ring binder on the shelf collecting dust. So I think those are the 2 points that I would highlight. I think they cut across all industries.
Thank you. Another question that comes up in different contexts, and Marcus, maybe I'll direct this to you, since you gave us an overview of response planning and preparation. What if a smaller organization does not have all the same positions as a more sophisticated company, doesn't have enough employees, for example, to have a CISO, a Chief Information Security Officer? How should a response plan be tailored to work for a leaner company if you don't have the resources of, for example, a large, sophisticated financial institution?
I would suggest taking primarily a 2-step approach. Think of your plan and the people who need to be involved, less in terms of positions and more in terms of functions they need to serve during an incident response. And then after you kind of take stock of the positions that are needed, someone obviously with some kind of technical sophistication, you're going to need someone with legal expertise, communications, depending upon the type of investigation. It could be human resources and other disciplines. Look and see who in the company has that kind of expertise, and whether they will have the time to be a part of a response team and have the time to actually get trained up for it. And to the extent that there are people available, they can become internal members of the team. And to the extent they're not, companies should look and think about external firms that might be able to provide team members for those purposes. Oftentimes, when you have a company with very lean staff, they also have found ways to do that very same thing to accomplish those functions with external parties that larger companies would accomplish through internal parties. So those are the 2 steps I would generally recommend.
That's very helpful. And in fact, a connected question, and Stephen, maybe I'll direct this to you since you provided an overview of active response. The one question that's come up in the context of this presentation and comes up all the time is, who should be in charge? in an active response situation of a data breach?
Well, in keeping with Marcus's comments, it certainly depends on the company, both in terms of size, to Marcus's comments, but also to the culture and its structure. Most companies have the CISO or the general counsel in lead roles, but again, the most important thing is for it to work for the specific company. And I would emphasize 3 principles in determining who the most effective leader should be. First, whatever the structure that's put in place, it needs to be collaborative. It needs to enable all the groups within the multidisciplinary groups in the firm to work together effectively. Second, there needs to be clear leadership. Whoever gets appointed must have sufficient stature to be able to lead the team. And third, however the structure is built, there needs to be sufficient accountability. And that both means accountability from the team leader down to all the individuals implementing the technical and legal response, but also upwards, even reaching to the board of directors, so that everyone knows who is responsible for what functions, and their performance can be measured after the fact.
Thank you. One question that has come up relates to something you discussed, Jeff, the cacophony of regulatory voices that can be relevant to a company dealing with a data breach. So how do federal and state regulators cooperate or coordinate when it comes to cybersecurity?
It's a good question. I think, it depends is the answer, but let me give a little bit more meaning to that. I think what you have in this country with our sectoral privacy approach is you also have a number of agencies who are responsible within organizations for implementing privacy regulations. Cooperation is important, obviously, to avoid overlapping or inconsistent requirements. And I think you see some of the federal banking agencies obviously working together. The state AGs historically have worked unilaterally, really, without much consultation with the regulators. I think there's been a good development recently in that the New York State Department of Financial Services last week issued a request to some of the other regulators to comment on the cybersecurity guidelines that it's contemplating promulgating regulations around later this year or next year, trying to solicit some views from them on what's appropriate. I think that's the kind of proactive cooperation really need out there so that, again, the financial institutions aren't subject to a varying degree of regulation or inconsistent regulation. So hopefully there's going to be more of that going forward. Everybody's really on the same team here when it comes from the regulator's standpoint. They're trying to protect the U.S. financial system and trying to protect the regulated entities. So there really should be more coordination. I think this is hopefully a good sign.
Thank you, Jeff. Unfortunately, that is all the time that we have. Let me just address one very practical question that has also appeared on the Q&A panel. The slides from today's presentation will be available to attendees after the fact, and you will get notice as to how to receive access. As mentioned before, if you submitted a question that was not answered, we will follow up with you directly. Should you have any additional questions related to today's topic, or if you would like a copy of the firm's guide, Preparing for and Responding to a Computer Security Incident, Making the First 72 Hours Count, please email Jeremy Fegley at jfegley@mayorbrown.com. That's jfegley@mayorbrown.com. Thank you again for your participation, and have